Hello and welcome to what promises to be an exciting session titled Innovation and Data Privacy Walking a Tightrope. We have the pleasure of having with us Justice V.N. Sri Krishna, retired Judge, Supreme Court of India, along with Ms. Jia Modi, founder AZV Partners, and Anu Tiwari, partner at AZV Partners. I now request Anu to please take over the proceedings.
Thank you so much, and thank you everyone for joining in. And a special thanks to Justice K. Krishna and Zia for making the time for this important event and session. So let me start by asking Justice Sri Krishna a question he may have been asked before, which has been a big debate on this topic. So, what departures do you see from the draft white paper of 2018 and the bill that was initially proposed to what finally came out in 2009? And maybe the more controversial question of what the reasons for those departures might be.
Okay. Your first part of the question is concerned, it's objective. The second part is the subjective answer. I'll have to guess. Okay. I see, I'll mention about 4 or 5 important departures. There are 3 sections where we had said that the the government individual unless there is a report is concerned, there is a parliamentary enactment and that parliamentary enactment confirm people should declare the proportion from red to smaller scale. The other department is completely dominating the data protection authority with government families. Which the act should come to force. What we have suggested with regard to the low level, there is a half solution proposed. So, the major one, the biggest one thinking that if personal data is accessed unless it is warranted by a parliamentary and the constitutionality of the very much
Got it, sir. So effectively, as I hear 3 points, and that ties very well into the next question, but just to summarize for everybody, I think the discretion that has been given under the proposed bill of 2019 seems far wider than probably what was envisaged initially, both in terms of the definitions, in terms of who it applies, or rather who it does not apply, which was the most important point, basis my reading of the white paper. Secondly, the way the authority, which is a very new authority, which will have wide powers, is proposed to be set up and how it will be constituted. So there were judicial members and subject matter experts who were supposed to be on the selection committee. All of that seems to have been diluted. So of course, given the consent requirements under the bill for the Data Protection Authority, composition is important. And I think lastly, just the construct that you had proposed, I mean, the committee had proposed in 2018 about mirroring of data and how it ought to be handled seems very different. So Zia, this brings me to the next point, and again, seems tricky legally, but would like to hear from you.
So, let me interrupt you for a moment. Before we go to the next point, you asked me a subsidiary as to what could be the motivation. Only, of course, it's pure guesswork on my part, but I would suggest that the motivation appears to be that whoever decided this issue was dominated by security considerations. the security agencies must have really dominated the thinking of the persons who drafted the 2019 bill. That is the only most charitable interpretation I can give.
Definitely, so seems like it, especially just the tech revolution in that 1 year of 2019 from, I think, given how fast geopolitics have evolved on this topic. Zia, any particular thoughts with this? Is this the right approach to lawmaking, that to on an important topic where there is still lack of clarity? And I'm sure if lawyers aren't clear, industry would be equally unclear on interpretations, definitions, scope, ambit. What would you want to see in the final version as and when it's passed by the parliament?
So I think, taking off from what Justice Sri Krishna's report and Bill said, basically we have to recognize that data is a fundamental right. And that has to be balanced against other considerations that will stand the test of reasonableness and will not be struck down as excessive by the courts. I think that's the balance that the Sri Krishna report tried to achieve. But what has happened is that there is now a feeling that the bill, unless it gets modified, has a big brother feeling around it. So what should be actually controllable by somebody other than yourself as a citizen? It should be something which the existing law permits you to do. So if there is really something which concerns India's security or which prevents or results in investigating a breach of law, in that case, yes, personal data should be accessible. But the way the exemptions are enlarged under the proposed PDP bill, and the DPA is now not really the end all and be all, because what can be added as additional categories of sensitive personal data can ultimately go to the central government. The DPA has discretion, but then the overarching controller is the central government. So I think that the feeling is that other than protecting personal data, the trend is to have full access to personal data. I think that is one issue. The next thing is that there are too many concepts which have been built into the PDP bill. You have extraterritorial jurisdiction. So even overseas entities which access data of Indian citizens have to comply. Back offices which have data which may have nothing to do with Indian citizens, they are sought to be brought in, and we don't know where the rules will pan out. And then, of course, the government can add new data categories, again, as I said, in their discretion. So what is sensitive personal data, what is critical personal data, what is financial personal data. And now, of course, this can be used as a G2G trade negotiation. I think for the fintech audience, the cost of this, which we'll come to later, is exorbitant. And the lack of clarity and convergence is also a problem. And then, of course, we need to maybe spend a half a minute on the fact that from personal data, for some reason now, even non-personal data has become the subject matter of a draft report, which was never something the Sri Krishna report thought was in the parameters of lawmaking. So those are a few points. And of course, as Justice Sri Krishna has said very often, the DPA was meant to be a committee of experts. What it is now proposed to be is bureaucrats. So does that give the citizenry a sense of government control, lack of independence, lack of expertise? I think these are all issues that need to be addressed.
Right, yeah, no, very, very valid points. And just Krishna, so basis at least my limited reading of the bill, even I wasn't clear if between a husband and wife, one could be a data subject and one could be a fiduciary, and hence be subject to the act itself. Which brings me to the question of exemptions, because in your chapter 7, if I recall correctly, of the white paper and the initial paperwork, a lot of thought through exceptions basis GDPR and global framework were envisaged. And what at least we find in the 2019 government bill is conceptually be it M&A exception or employer-employee or credit bureaus or banks or for reasonable purposes, all of that has been talked about, but it's ultimately subject to the authorities' approval. And approvals, as we know, how they work, how long they take, becomes a bit of a difficult issue. So what would you want to see, at least in the final version on this? Because I'm cognizant for technology and fintech world, this is a very, very big issue. Unless there is a clear line between what is not covered as opposed to what is covered in the final act.
Basically, the difficulty is, are we attempting by this law to throttle all research in every subject? Now take a simple thing. What is the impact of COVID-19? Does it really come to, in terms of, let's say, male and female, or in terms of age, or in terms of status in life, or in terms of residential status, or in different tracks of the country, or different tracks of the same city? How to determine this? You determine this by a fundamental research based on data. Therefore, we had said, for the purpose of research, whether it is history, economy, mathematics, or health, or law, you need solid data. But yes, data need not tell you Mr. X had this disease or Mr. Miss Y had this disease. It just gives you numbers saying 100% have been affected, like every day you read in the newspaper or you see it on the screen today in TV, saying that 10 million people, 10,000 were affected, etc. Kind of data is permissible, and that should be an exception. Now, historical data, you will never be able to do anything unless you go in. Now, you want to find out whether Akbar was son of Jahangir or something like that. Without personal data, how can you do it? Therefore, those categories or exemptions must be built into the statute. They must be hardwired. Now, if you make it software and subject to discretion of the government, then you go back to 1984, as I said, Orwellian state. Whatever you want, take permission of the Data Protection Authority, which means really virtually the government. That cannot be done. The law should not be suffocating the citizen. In fact, it should allow him to breathe and stop his breathing if he misbehaves. That's all. I can't hear you.
Very, very fair points, Justice Sri Krishna, which brings me to the next very relevant question which we've been asked many times, especially as practitioners by different industries. And this would be a question to both of you. Typically, in Asian societies, with 10 people staying in a 6x6, privacy and data is the last thing one thinks about. And I remember till 3 years back, there was no debate around data in our country. And suddenly in the last 3 odd years, we don't even just have after the Puthuswamy judgment, not just the data protection bill, but we have RBI coming out with data localization directive. There are NBFC categories, account aggregator in particular, where there's a lot of focus and language around data and access and consent. We have telecom regulators who have data related laws, access storage for a long time. There is e-commerce policy, draft policy, which talks a lot about data. There is OTT guidelines. So suddenly, from in 3 or 4 years from being no data law, and I remember only the ID Act, SPDI rules were the consent data laws in the country. There's just too many laws. So would both of you feel that the approach on this one is to maybe only let the proposed act and the Data Protection Authority deal with the subject matter, like say how it's happened with competition laws, where cartel, horizontal restraints, combination, whether it is good, bad, is only seen by the CCI and not by SEBI, RBI? Or is this something similar to a consumer law architecture, where there is a consumer act at the central level, but every regulator like SEBI, RBI, they have their own stakeholders like depositors or unit holders? What would be the right approach to avoid conflicting positions from regulators and under the proposed act?
Basically, my own take is that all laws must be citizen-centric. They are meant for the benefit of the citizens. They are not meant for the benefit of the regulator or giving him more power and more turf. Now, the difficulty that you posed, that having this, the regulator having problem with the other, is because of the turf fight war that has been going on in this country between different regulators. Now, see what, for example, Competition Commission. Now, you remember that famous case where the Geo people had some investment in Facebook and there was a big furor. Now, whether that amounts to competition computation violation of law, or it is an abuse of market, is that people must be left to computation. All these days we didn't have that with regard to computation entering the picture of data, because nobody considers data as an effective thing. Everybody comes in terms of sustainability, market sales, asset value, and all that. The data is also one of the issues. There could be unfair computation. Therefore, yes, leave this to the data regulator to split data across the board. But then if it is, this is something I had already considered. If you go back a little back, the question of legislative reform was formed. Is every regulator in the political field considers himself to be a sovereign. He would not look at the others. That led to work for which the citizen is the one that is going to be affected. And when you look at what happens, then you have the effective body. It will comprise all these take a decision which will apply across the board, so that the citizens and the business they know how to do business, and the citizen knows how to conduct himself. Otherwise, this kind of things will, you can't have no this person and that. You must have an overall. Somebody must take a holistic view of the issue before cramming it. That is the way I look at it.
Zia, your thoughts?
So obviously, there's hardly any scope for disagreement with what BNS is saying. I think that one of the feelings is that whilst the report and the bill was coming out, perhaps some regulators actually jumped the gun. So if you look at what is the state of play today, RBI has already given its directive on what it believes should be local data localization. The TRAI is also putting forward provisions which are not yet effective, but those along with the regulations may again have a certain path forward. So while we are still debating the bill, seeing what will be the final outcome of the bill, you have a state of play where there is also already regulation in place. So if, for example, the Reserve Bank allows you to process overseas data overseas and bring it back within 24 hours, the Data Protection Authority may have a different view. Financial data is part of personal sensitive data. So that is going to surely be the subject matter of how the DPA decides it will move. In the meantime, RBI has already taken a position. So are we going to be in a state of play where the final Data Protection Act is going to be at loggerheads with important regulators? And what does that do to fintech players who have already started working along a certain path, spent money, invested in a certain architecture, only to find that that architecture then has to be reworked? And large multinationals, of course, are going to be again in a quandary because they've had to comply with RBI, like banks and MasterCard and Visa. And if the DPA goes a different path, it is going to be a huge problem for them.
That is why, can I interrupt you for a moment? That is why in England, when they had this difficulty of regulatory turf wars, they used this mechanism of oiling the troubled waters by having a memorandum of agreement or between different regulators saying that, okay, this is what we will do, this is what you will do, we will do it jointly. That kind of a mechanism should be all. Now, we don't have that in India, do we? If we had it, you wouldn't have had this problem at all. If you don't want to unify the regulators, at least have a working memorandum saying that, all right, this is what we will do between the two of us. The idea is to prevent the citizen being exploited, not fighting with you mutually.
I think if I can just make a comment, I think, Judge, the problem is that government is seeing data as a national resource. And the Supreme Court has said it's a fundamental right. And I think that's the diversion in a thought process. So even if regulators collaborate, if the mindset, as you say, is not to protect the citizenry, but to have access and control, I think that is the dilemma.
See, unfortunately, all natural resources, whether it's oil or land or space or your airspace, everything is said to be a national asset. But this is my right. People forget that. This is my fund. Why? Because it has been founded in Article 21, not Article 19. Please note, it is not founded in Article 19. It is a 21. 21 must have greater efficacy, must have greater protection. That is what I have been crying over all these days. That is why I said, hey, without an appropriate parliament which can stand the scrutiny of the constitutional parameters, don't even touch my fundamental right.
No, all very valid points, Zia, and the whole issue on this one is because there is a non-obstant clause in the bill. So ultimately, for fintechs, for technology, and this is not just a question of MNCs where technology is based outside of India, where data is stored outside of India. I mean, today, access to data, consent architecture. So because when you have 10 different goalposts, I think the bigger worry industry seems to be having, which probably, hopefully in the final bill version, will see resolved. Which standard to follow, which is not the most conducive from an innovation standpoint. But do you Zia and Justice Shri Krishna, see this as a challenge to innovation, which is a question we get very often with any new tech lash or tech reg, as it is famously called, coming out?
That is why the committee which I headed made a very sensible suggestion. Sorry, I am being a little immodest by saying it's a sensible suggestion, but a suggestion which in retrospect I think is sensible. How do you do it? You lay down your standards after continuous dialogue with the stakeholders. Now, let us say you are a data controller. See, the central data controller is only an overarching body. He will have to have state data controllers affiliated to different industries. Now, let's say you want to say how to help it. Continuously have a dialogue with them. When the shoe pinches, moderate it as necessary. And as a result of consensus, bring forth your regulation. There can be a problem at all. This regulation has been evolved as a result of one agreeing to it.
Right. No, very fair point. And given I'm being told that we have 5 more minutes and we may have some audience questions, so I'll ask a closing remark question for Zia, which is a question we keep getting asked many a times. Given that we all are doing this as a virtual event and not a physical, and everything has moved virtually, and just the amount of data that is being created, is this even the time to have a data protection law of this nature? Should we defer it? Are we even prepared? Do we need this? That's the whole issue from an India standpoint, where there are far bigger issues than this. And would definitely love to hear from Justice Shri Krishna also what he thinks on this. And I know you have strong views on this topic, sir.
I'll straight away answer and say, first solve the basic difficulties of the citizens, assure them clean air, clean water, some roof on their head, basic education. Without this, don't even talk of high-tech things. That is my fundamental take on this in any law, on any subject.
Zia?
Well, I think that, there's no debating that, except that I think that today we're on the verge of a large, major internet overhaul. We have 5G coming up, and so there are arguments both for some more regulatory oversight, as the Sri Krishna report suggests, and also the reduction of overstringent regulation, which, if the DPA bill is not watered down, will prove completely unsatisfactory.
So I hear a consensus that probably this bill should be deferred by a year or so. Definitely not this year, just given the challenges, because delivery of every service now is online. So it is not going to impact, just a small subset of technology or fintech companies, but everybody. Great. With that, I think I just had one quick question for Justice Shri Krishna in particular, given I believe we have 2 minutes left, unless any audience questions come up. I think one point we didn't talk about, Justice Shri Krishna, is the whole non-public data debate with the whole Gopalakrishnan committee report coming out. Honestly, I have never understood this concept, despite having read a bit on this. Do we need this? Because we are the only country who's talking about a non-public data, community data. And again, there are different concepts such as public, non-public data, private non-public data. Do we need a separate regulator for this? What are your thoughts on, isn't this taking the privacy protection debate a bit too far?
That's the personal data. I had a very quick look at the Gopalkrishna committee report on non-personal data. That is not so much bothered about data protection as we are saying. It is trying to ensure that community data or public data is for being utilized by persons for research and for innovation, etc. I mean, as a concept, I don't disagree with it because there the question of fundamental right doesn't arise. Supreme Court has not said that your community data is going to be your fundamental right. It's your right. Please note between fundamental right and right. Now, it is your right. Monetize it. Use it in the best interest of the only thing is contour the law. I'm not sure how the report of PFC and science how it will develop because I by a set of bureaucrats. They will put in their worth of and then whatever comes out.
Great, great. So that's a very fair point. One quick audience question we have for both of you has been actually been asked by many historically also is do you see lending and especially fintechs in particular being impacted by data protection bill? I guess the answer is definitely yes.
Yeah.
But is this something that they can live with, or they should start worrying too much about this to stop thinking about fintech as a space? I would think it's the former than the latter, but would love to hear from both of you before we. I think we are out of time before we close this. And is there any closing remarks both of you have on this?
I'll give a quick answer to that and say every law impacts businesses, and businessmen are smart. They know how to live through the law and live along with the law, and ultimately they will manage to still survive and come on top. This is no exception. That is all that I have to say.
Is there any closing thoughts on this?
No, I think that what Judge is saying is correct. How can fintech right now live without the heavy reliance that they have on behavioral data, preference data, transaction history, new technological tools, AI? So in a way, their fintech's dependence on data has obviously come to stay. I think their hope has to be that there will be a sensible approach by the regulator such that both citizenry is protected and business thrives.
And innovation is even something well, that's what Madam Modi.
Okay.
Okay, then on
That's it
behalf
from
of
us, and over to you, Doctor. What do you now?
And thank you, Anu, for moderating the session. Much appreciated.
Thank you, Anand. Yeah.
My pleasure, Zee. My pleasure, Doctor. Just.
thank Anu for the moderation and thanks to the panelists for a very exciting and invigorating session. On behalf of IMI, we would also like to thank our sponsors, CreditWatch, Tech, Bank of India, Ongo for their support, without which it would not have been possible. We now conclude this session and thank you once again to all of you.